Hi, good evening, Jillian and Jane.
Hi, good evening.
In okay, so we are going to wait a few minutes as we normally do. So you guys check in a few minutes time. Hi, Claudine. Minutes. Can you hear?
Hi, sorry, I'm cutting out there a bit.
You can. Hello?
Okay, I can hear now.
Okay, is that better? Sorry, man, the internet is not so, I don't know what it is. Okay, we've waited long enough. I hope Jane comes back. Did you say anything? Okay, is that Jane? Welcome back, Jane. Can you hear me, Jane? You can, then just put up your hand. Raise your hand. Okay, good. Internet is up and down today. So yes, we continue today, guys, with you know collective labor law, which is the study of laws, the same labor laws that we've done before under under individual labor law, but now the only difference is how does this apply when the employees are large in number, when they are groups of them? Okay? Do they have the same rights that individual workers, employees have under the Basic Conditions of Employment Act, under the Employment Equity Act, under the Labor Relations Act, under the Skills Development Levy Act? Who would care to comment on that? Do they have the same rights, or what? What is the situation? If you work for Dr. Abrams as an assistant in the doctor's surgery, okay, and you work Monday to Saturday basically, and You work certain hours, and you get all these. The doctor can't dismiss you. He can't discriminate against you. He can't, conduct your employment in an unfair manner. Do you have the same rights? I mean, in principle, at least, that the many workers that work for, let's say, SA breweries. There are many, many workers on this production site and many kinds. In what respects? Um, Tell me firstly, do you believe that there's much difference between the two? Or what do you think? Are they the same or are they different?
Yes, I also think they are different.
Okay. But in what way are they different? Good evening, Celeste. So in what way are they different, guys? Any comments on that? Well, that's just the thing, guys, that they may have the same, the employees that are, grouped together under representatives called unions commonly, have the same rights and in some cases better rights than individual employees. Okay, because the law permits the employees and the representative unions to enter into discussions with the employers on matters of what we call mutual interest, to discuss these issues and even to come to a point where they can come to a decision. And what do we call this process now when they come together, employers and employees representatives? What do we call that process now? Where they sit together, they can argue together, they can, as long as an issue of mutual interest, that concerns both of them. It could be working conditions, it could be pay, it could be the way they are treated. It's broadly called matters of mutual interest. And the idea is so that they can both, rather than expect the legislature, the lawmakers, parliament, to make a law to strictly, make exhaustive rules on what must be paid, what the conditions should be, but leaves it up to the parties to negotiate. Okay, and what do we call, and to come to an agreement? And what do we call that? That is roughly called the bargaining or the collective bargaining, or coming to a collective agreement. Okay, where the parties are basically left. It's left up to them to come to an agreement. Well, they can negotiate, and they can negotiate, from the basic minimums that are allowed by law, and to terms that are favorable to the employees. Okay. But to give you an example, guys, if you work for somebody and it's like just a few employees, and you work for your boss has got, he makes the decisions, of course, as the employer. To negotiate with him, sometimes you may about working conditions, working times, pay. You could negotiate, but pretty much as long as he sticks to the basic minimum allowed by law. And when I say that, I mean as allowed by things like the Basic Conditions of Employment Act, Employment Equity Act. If he sticks to those, then there's very little that you can do to change him, right? Unless he voluntarily gives you something better. Okay. If you work for somebody and you're on maternity leave, you're supposed to get up to 4 months maternity leave, and you must you're given that leave, and you at least have the expectation that when you come back, your job will still be there, and that during this time you can claim from unemployment, the unemployment insurance fund. But it is sometimes the practice, you can ask your boss, will you not then pay me while I'm on maternity leave? And can you force the boss to do that? Hey guys, do you think you can force the boss to pay you for work that you do during maternity leave? You can't force him to do that, but he, out of his own will and out of his own volition, can decide to do that. Okay, so that is an example in individual labor law where the employee cannot receive less than what's required by the minimum conditions as prescribed by the Basic Conditions of Employment Act, but the employer and therefore the parties can obviously come to an agreement for anything above that. Now, if we look at collective labor law now, okay, yeah, the parties have a bit more clout because they are larger in numbers, so they can negotiate if it's a matter of mutual interest. The law says if it's a matter that affects both of them in the workplace, then it's open for discussion between the two of them, right? And they can come to an agreement. And the thing is, once an agreement is reached at that level, a collective agreement is reached, it is now binding on the parties in all the and all the employees as well that are formed, even if they're not members of that trade union, they now will fall under that agreement that has been brokered on, not even on their behalf, but by the trade union. They will now reap any benefits that the agreement that has been reached between the trade unions and the employers. Okay. So this is the collective agreement process now that is set up in such a way to compel the parties to into. Now, there's a few questions I want to now just discuss with you guys. When we said that the parties can strike, right, and we said that the strike is either partial or complete refusal to work, right, or stopping people to work. And why would the people strike? What is the reason? Can employees strike for any reason? Guys, can employees strike for any reason? Can employees strike for any reason? Anyone? Can anybody tell me? Can employees strike for any reason? If they're unhappy with working conditions, can they just strike? What are the limitations to that? No, so employees cannot strike for any reason. Basically, it's too broad. You just don't have that right to strike for any reason. It must be a matter of mutual interest. That must be the cause of the strike. That they have a matter of mutual interest between themselves and the employer, and they want the employer to remedy it, to resolve this dispute they have regarding this mutual interest between the two of them. Okay? It's very important that strike is not just a protest, a wild protest, but it is quite limited. And when we try to gauge whether a particular strike, particular action rather, does constitute a strike as defined in the Labor Relations Act. We need to look at the definition of a strike and to actually look at what the issue is. Do they have a definite reason? In other words, is there a matter of mutual interest between them? Whether it is working conditions, perhaps, whether it is, the pay that they are increase in pay, in a dispute about payment, about wage increases. That's the one thing. And is it for the purposes of wanting the employer to come and resolve the dispute? Okay. I've spoken about this before, but definitely this whole exercise, this whole module needs to be explained in a particular way that everything should come together. Now, I just wanted to ask you here now, what can you do? Because the whole thing is set up, as we mentioned before, that the whole system of collective labor law is set up in such a way to force the parties to come to an agreement, to sign that collective agreement, right? Which has the status of a binding, it's a binding document, and it binds the employer on the one side and it binds all the workers on the other. Okay. Now, because it forces that, what happens if one of the parties, especially the employer now, imagine there was disputes about pay increases, right? And this is a very common dispute, matter of mutual interest. Now, imagine that in a certain demand was made on the employer that, look, you haven't increased our wages in 3 years, or rather the last collective agreement we had was that we can review our wages, our wage increase in 2 years' time. Okay. And now the 2 years have passed. We now want you to come and sit down and talk to us about the amount of increase of our wages. Okay. Now, what do you do now? An employer, if he refuses to bargain with you, refuses to come to sit with the employees and the unions, does that mean the whole process is now stifled and stunted now because we can't talk? They don't want to talk to us. What does it mean now? What would be the next step if an employer refuses to bargain with employees or trade unions? What would you do? Trillian, Jane, Celeste, what did you do? So why am I not getting my messages on? I'm getting messages on my phone, but I see that it's not coming on my computer here, on my laptop screen. Just trying to figure that out. Jane says go to the bargaining council. Yes, okay. That would be the normal way to start. It starts there, yes. And now at the bargaining council, let's say the employer doesn't, what happens at the bargaining council, Jane? Right there, the bargaining council or the CCMA, if it applies, will be the next step. But so what will happen at the bargaining council? tell them your problem. Now remember, when you go to the, okay, I see your response here. Tell them your problem and ask for assistance in the matter. They will send a representative to the workplace. Now remember, to start the whole process now, okay, you must refer it to the bargaining council, the CCMA, as you said. Now at the CCMA, you need to set it down for, you know, for conciliation or mediation. A representative from the CCMA won't normally come to you, okay? You need to go to the CCMA. It's not how it's normally done. Workers are represented by shop stewards who represent, you know, the trade unions, and they in fact approach and you know, discuss matters with the employers. And if the employers are ignoring them, they need to go to the CCMA. Now, what must happen at the CCMA? And how long will it take at the CCMA? Going to the CCMA is the opportunity for the parties now to talk. Well, what happens, and they should try and talk. Okay? That is what the law asks and requires of them. So section 64 of the LRA says that they've got up to 30 days, basically. They can't discuss or, you know, mess around for too long. They've got up to 30 days to try and come to an agreement. Okay, so they can either come to a point, you know, that they realize even before the 30 days are up that, okay, we're not resolving this. Let's say the employer refuses to talk, he refuses to bargain, right? Well before the 30 days. Or he bargains, but he bargains in such a way to waste time, and he's non-committed, and 30 days go by. It's clear that this is going nowhere. What must the CCMA representative or the bargaining council now do? If the matter remains unresolved, and or 30 days have gone by and they still haven't resolved it. They're working on it, but they haven't come to a decision. But 30 days have gone by. What must the CCMA do, or the bargaining council? Okay. The bargaining council must issue a certificate, right? Arbitration, Celeste. It is, well, you see here, to go to arbitration, you know, basically, it is not the point here when strike action is the main objective. Okay, yeah, all you need is to get this, to get the strike declared lawful, is to show that, look, this has now gone on, okay, for more than 30 days, or if after even a week we realize we're not going to come to an agreement, we need a certificate from the CCMA to say that the dispute has remained unresolved. Okay. And once you have the certificate that the matter remains unresolved, there's no need to go to arbitration. But now you are entitled to have a strike be declared. Okay, you remember I mentioned this before, that there are a couple of steps that one needs to take before strike can be declared lawful. Okay, now these are the steps. The refusal to bargain by an employer is also, all you as an employee need to do then is to wait for either the 30 days to go by, or if they refuse to bargain continuously before the 30-day period goes by, then the parties can then use that as a ground to say, well, fine, done all those things, we're giving you 48 hours notice that a strike will commence, you know, or if it is a state, the state is the employer, you need to give them like 7 days to notice that, look, a strike will ensue. A lawful strike will ensue. Okay. So it won't be by arbitration, because what will we achieve at arbitration? The arbitrator can't make an award to say, well, yes, the increase must be by the workers want 20%, and the employers are offering 12. And the employees are saying, no, we don't want 12, we want 20%. And now there's a deadlock. So what's going to happen now? They should come to an agreement now. But the employer is not budging, neither are the employees. So they resort to the extremes, and that is a strike on the one hand by the employees and a lockout by the employers on the other. As long as they follow that process, then the strike will be considered lawful. Is that clear, guys? So, cool. Now, excuse me. Once the strike has been considered lawful and you now inform your employer, through the union informs the employer that, look, okay, we've tried to talk to you. You are either, you're not being willing, or you're simply refusing, or you're just not engaging us, or not prepared to accept our demands. We are now, and we've gone to the CCMA there to try and resolve it, and it didn't get anywhere. 30 days have passed. In any case, we've got our certificate that the matter remains unresolved. And now, once we get that from the CCMA, we can go to can inform the parties that we will now be instituting a strike. You must give them at least 48 hours notice before the strike is intended to commence. Okay? But if the state is an employer on the other side, then it needs more notice than that. And you can think why it needs more notice. Okay, so what I want you to do to answer for me now is, I'm just going to excuse for a minute or so, 1 minute, guys. But I want you to ask me now, once the strike is declared lawful, okay, what now? You've given the notice of 48 hours, what legal consequences ensue now? Back in 1 minute. Okay, guys, I'm back. And my question was, are you all there? Hands up if you're still all there. Okay. Okay, good. All right. Good to know. So now the strike, they went to the bargaining council, the CCMA, they try and, negotiate or to talk about the issue, to come to a collective agreement. That's the main idea. They didn't, right? 30 days go by at the CCMA, or it's even clear before the 30 days that both parties are saying, nope, there's no way we're going to agree. They don't want to budge on this interest, on this matter that they are negotiating about. And they've got that certificate, that important certificate of confirming that the matter remains unresolved. Now they can, announce, either party can announce that, look, we're going to go into a strike now, and they must give them 48 hours notice. And the employer, on the other hand, can also say, well, you are also notified then. See, there will be no strike if you don't give notice about that strike, okay? That is the other thing. The certificate that the matter remains unresolved is important, that you're getting from the bargaining council. But if you don't notify, because the employer doesn't know your intention even at that point, or you may know broadly what your intention is, but there's nothing in writing to confirm, no notice. You need to give him a notice. You can't just suddenly rock up, with striking. You need to give him at least 48 hours notice. That's fine. Since you got that certificate, we're giving you notice that strike will start at this time. And it can't be less than 48 hours. And once that comes into effect, this was my question, what are the legal consequences now for the employees and the employer? We know they can strike, but now what are there any protections that are given now to the parties? If all these requirements have been met for what we call a protected strike or lockout?
I would say the employees cannot be dismissed.
Yes, absolutely. Right. Now you get special protection. The employees cannot be dismissed now. Okay, now remember when you say that statement, when you make that statement now, James also made a point here. They may not be laid off and must be paid. Now this is the thing, guys. We must just be clear now. There's a bit of truths and a bit of non-truths amongst the answers here. You're right that first let's deal with this one. They may not be dismissed, okay, and they may not be laid off. Is that like completely true? Is there any exceptions? Are we back? The internet is acting up. Okay, it's back. My hands up again, just quickly to show me you there, because I'm getting this internet going on and off here. Good. Okay. So yes, you're right, but you must qualify that answer, guys. They may not be dismissed while they're striking, and then they can't be dismissed for striking, but they can still be dismissed for misconduct or operational requirements. Yes, Julian, you're right there, except for misconduct and for operational requirements. So can someone give me an example now? I'm an employee. The union has now declared the strike. The strike is protected. I can't be dismissed for not pitching up at work. I can't be dismissed for joining a picket. I can't be dismissed for striking, right? And waving a banner in the air and saying, I want 20%. So I can't be punished for that. But how can I then be charged for misconduct if I'm not even at work? How's it going to work? Guys, how's it going to work? What misconduct could I commit while I am not at work itself? Yes, violence, exactly, because this is especially there, right, you are Jane and Celeste, that this is especially there because people, what do you often find when strikes happen? Violence, destruction of property, intimidation of workers, threats to the employer. threats to management, you know, so all these things go on, and those are acts of misconduct. And if the employer, you know, gets wind of it, they can have a disciplinary hearing and call into a disciplinary hearing and say, well, yes, you can strike, but you threatened our manager that if he doesn't, you know, do, you know, comply with your demands, that you're going to have his family killed. And these kinds of things exist in some cases, you know. So that could be an act of misconduct. When you damage property, it could be an act of misconduct. And the other reason you can also be dismissed is for operational requirements. So you're protected from not being dismissed for striking and related rights, but except for misconduct, which you guys gave good examples of. Now, what are operational requirements? Think back to your studies in individual labor law. Right, when operational requirements, and give me an example of how that would fit into a strike situation. You gave a good example of the misconduct with the violence, yes, and the destruction of property. That is correct there. But how can the operational requirements work now? How can you, because you see, we must examine these two weapons very carefully, the weapons of striking and the weapons of strike and locking out. Some people think that, oh, you know what, these people are locked out, fine, but now what kind of punishment is that now while these people strike? You know, how effective is that as a tool? Because striking, you must remember, not as someone mentioned here that they must be paid. No, you're not going to get paid while you're on strike. You're not going to get paid while you're on strike. If you strike, but basically what you're saying is you're not taking payment during that time. It can be very hard. And the employer will be within his rights not to pay you for that period. He can't dismiss you, but he also is not obliged to pay you while you're striking. And that makes good sense, because why would you want to pay somebody who's not doing the job? He's striking, yes, but at the same time, he's hurting your business by not doing the work and producing the things that you need. So, operational requirements, who can recall what that is? Let's quickly look at that. Operational requirements. Think back to your days of individual labor law. Remember, an employer can dismiss employees either for misconduct, incapacity, or operational requirements. And operational requirements is a process where the employer says, due to technological, economic, or structural changes in the business, that they need to make such changes, and now we can't keep you on. We can't keep you on any longer. All right. So how does that particular ground of dismissal fit in with striking workers? Anybody? Because there's a whole process. It's not an easy way to dismiss somebody through operational requirements. You must go through a whole consultative process as the employer, and you must look at the least damaging situation to the employee. And dismissal must be the last resort. Okay, so section 189 of the LRA and 189A, capital A, which deals with the situation when there's an employer with more than 50 or 100 workers. 50 workers. then he needs to follow a particular procedure. Okay, so you can't just dismiss somebody on the ground of operational requirements arbitrarily, just like all the other grounds of dismissal. But this particular procedure involves a lot of consultation, exploring ways that you can use besides dismissal. And when dismissal is finally decided upon, you need to look at the way that does least damage. So, for example, when dismissal is finally decided upon, then it is normally the people that have came in. They work according to a process called LIFO, LIFO, last in, first out. But before you even come to that, you must look at various other things, and you must consult with the employees and the trade unions to look at ways to avoid it. So this is the other ground of dismissal that an employer during a lockout and a strike can employ. You can use this method that, you know what, people have striked, I've lost business, and I can't maintain you anyway. So let us look. I want to hear from you what else I can do. Okay, so this is another thing, because strikes have damaging effects. Right? If you have a very large workforce all over the country, for example, and they all decide to do a national strike, and you will lose so much money and revenue that you won't be able to maintain these people anymore. So the very strike action that the employees embarked upon can actually be, if it's not done carefully and considerately and taking into account many and all the factors and considerations, it can backfire as well. Okay, you may have striked, cause damage to the employer. Now the employer can't employ you anymore, and he needs to look at getting rid of you, and he must just consult you. Any questions on that, guys? Yeah. Just give me a second. Hold on 1 minute, guys. I'm back, guys. Sorry about that. Small kids running around, even at my office here at home. So sorry about that. So we must be careful here. The employees are not going to be paid while they are on a lawful strike, and they can't be dismissed for striking, but they can still be dismissed for misconduct or for operational requirements, which we explained now. What other consequences now happens? So there's limited protection for employees and employers. Okay. So locking you out so you can't do the work is not considered a breach of the employment agreement by the employer, and he doesn't have to pay you. Right? This is the other important thing. And this is now, how long can the parties hold out? So that's why I said it must be carefully thought out. It must be, a lot of factors need to be considered, and that is why if you look at it, certain information is required. Certain trade unions have rights to certain information. Majority trade unions can insist also that look, but the LRA gives him the right to disclosure of information by the employer. So if the employer is perhaps lying about things, what they're making, and you know, the financial situation of the employee, the trade unions can insist that we must be given that to see. And many times it's about the interpretation of these financial documents and statements that may lead a party either to decide to strike or not. Okay, so when you look at financial statements, you know, it needs to be explained, and they look like the employees, the employer is perhaps not spending the money wisely, and it just shows how far the rights of an employee go. You know, they can insist that you give them information at the runnings of the company so that they can be in a good position. What else ensues as a result of a lawful strike now? Of course, we know you cannot discriminate against, the employer cannot discriminate against the employee for striking, right? He can't be dismissed, not only be dismissed, but he can't be discriminated against, okay, for exercising these rights which are constitutional. So what would happen now if an employer, you know, perhaps he identifies that, you know, these are like certain employees that are instigating uprisings amongst the employees and encouraging them to strike, and he doesn't like it, you know, because of what these employees are doing, or certain employees doing, and is that it? What happens if the employer decides to dismiss such an employee? What are the consequences now, guys? If an employer sees that there are employees who have become involved in the strike action and he doesn't like it, and he decides to dismiss them, perhaps not for striking directly, but the particular involvement. In other words, you know, those constitutional rights, you know, it's involved in the activities, or, you know, just by joining the union. Let's say, you know, you get people that are undecided whether to join a union, but when they see the benefits of grouping together, they weren't members of a union before, so now they started becoming members. And when the strike happened, they took an active role. This the employer did not like, and the employer dismisses them for that. Okay, what could happen now? If that were the case, what would happen? Okay, Celeste and Jane, it's unlawful. You can't do it. There's no valid grounds. Okay, guys, you know, that's true, but it's a very broad description of it. So you need to like be specific in this. It's true that it is unlawful for an employer to, you know, to prejudice or to dismiss somebody for striking or becoming involved in strike activity or union activity, right? The constitutional right. So what are the consequences now? What could the employee do? Yes, of course, that we know you can do that, but there's a twist here, Jane. You can go, definitely, but there's something extra here in this particular step, or this particular act on the part of the employer against the employee. That's what I'm looking for. Celeste says the employee can approach the CCMA and the employer may be required to pay the employee 12 months salary. That is the normal relief, Celeste, for an unfair dismissal. That you would ask, you can ask up to a maximum of 12 months. Not that you will get to 12 months necessarily, but you may ask for up to 12 months compensation if you can establish that you're unfairly dismissed. We know that this is a particularly unfair dismissal, you know. So what I'm hinting at here, guys, is this is an example of what is known as an automatically unfair dismissal. Okay. Remember, unfair dismissal, a general unfair dismissal is where you have been dismissed for reasons that were not substantively and procedurally fair. Okay, that's a normal unfair dismissal. You know, it was for misconduct, incapacity, or operational requirements, and the employer didn't have a good reason to do it, and he didn't follow procedure or follow procedure, and you can get compensation. But there's a particular ground in Section 187 of the Labor Relations Act that says that you know, a dismissal is automatically unfair. Okay, it's automatically unfair if the reason for the dismissal is that the employee participated in, or supported, or indicated an intention to participate in or support a strike or protest action in terms of the LRA, in terms of Chapter 4 of the LRA. Okay, so what's so special about an automatically unfair dismissal? Okay, and you guys can look at Section 187. You know, that was just one of the reasons. There's other grounds of automatic dismissal, but this is a particular one which has been listed as an automatically unfair dismissal. Different from an unfair dismissal, it's considered automatically unfair. In other words, if that evidence is proved, you know, that my dismissal was because I joined a union, I had joined it before, and the employer, I told the employer this, and the next thing I knew, I was informed that I was called to a disciplinary hearing. If the employer is trying to hide the reason for the dismissal, I was called to a disciplinary hearing for something that I didn't do, and I was found guilty and then dismissed. But in reality, it was I got evidence to show that I was only dismissed because of my activities in the union activities for protesting and for striking, etc. Okay. And once a dismissal is automatically unfair, guys, it attracts compensation up to 24 months salary, not 12 months, but 24 months. Okay, 24 months salary. So this is double the normal. This is double the normal, what one can normally claim for an unfair dismissal. If it's automatically unfair, then a party who can prove this is entitled to ask that not only can he be reinstated, but he can be, you know, be given double the compensation that is due to him. Up to double. Okay. Yeah. Section 194, subsection 3. The compensation awarded to an employee whose dismissal is automatically unfair. Okay, Jane has got a question here. Can someone who was automatically dismissed be reinstated or re-employed? I would say yes, that is within the discretion of the arbitrator or the labor court, the judge in the labor court, and they have that power to do that. In fact, they're required to do that when the parties want it so. If the employee wants it, then the court will give effect to it. But as long as the employment relationship hasn't broken down, right? The court can't force you to go back to a place you don't want to be at. Okay, and in the same way, the arbitrator will look at, does the employer still want you back? And if not, then they also will have that difficulty, so they will judge that. But they do know the value of a job, because going to be reinstated means now you get to continue working and you continue with that benefit of a job and an income, and in addition you get compensated for whatever you can prove. So yes, that is one option that can be reinstated. So very quickly, let's just look at those list of items in section 187, guys. It's important. The automatically unfair dismissal. You may or you may not have dealt with it in individual labor law. I think you should have, but just to refresh your memory. So, if the reason is when you participate in a strike or any of those activities, and look at the wording of this act, it says that you participated or you supported or indicated an intention to do this. So maybe you didn't even strike, but you said, I'm going to strike, but you didn't do it, but then you were dismissed for that, then it would be an automatically unfair dismissal. Another ground for an automatically unfair dismissal is that the reason must be that the employee refused or indicated an intention to refuse to do any work normally done by an employee who at the time was taking part in a strike that complies with the provisions of Chapter 4 or was locked out, unless that work is necessary to prevent an actual danger to life, personal safety, or health. Okay? So this is where your employer has locked up people out. You are still, you're not on strike, but you're forced to do the work of the striking party. And now you're refusing to follow instructions for that. That would also be, and you get disciplined for that, dismissed for that. That would also be an automatically unfair dismissal, unless what the employer is asking you to do is a matter of, emergency almost, because it's a danger to life, or personal safety, or health. Okay, so look how far it goes to protect the employees. So those who are not on strike, you don't have to do it. But so if you're working, but you can't be compelled to do the work of the people that are on strike, and you're forced to do it and dismissed for that, then it's an automatically unfair dismissal. Okay, and it's also linked to collective labor law. So another ground for automatically unfair dismissals is a refusal by employees to accept a demand in respect of any matter of mutual interest between them and the employer. Can someone explain what this means? A refusal by a worker to accept a demand in respect of any matter of mutual interest between them. Can someone perhaps tell me where this would fit in? Where this would fit in? Employee is telling you to accept something and of mutual interest, and now you refuse to accept it. Where would this come? Where would this fit into the whole process, guys? Think about it. Where would this fit into the process? A refusal by an employee to accept a demand by an employer about a matter of mutual interest. No? Well, Okay. Jane says a collective agreement. The issue was discussed in solution. Now the employee doesn't want to accept this. Close, yes. It's in that process, yes, of negotiation, coming to the point of trying to reach a collective agreement. I'll give you an example. Wages, a matter of mutual interest is pay increases. Right? That's a matter of mutual interest to both. The employees want 20, the employee is offering 12. Right? So they're deadlocked here. Employer says, well, I'm giving this to you guys, 12% increase. If you don't like it, if you don't accept it, I'm going to dismiss you. Okay, people don't accept it, they refuse to accept it, and they get dismissed for that. And that is an example of another ground for automatically unfair dismissal, which carries the same penalty as the other two grounds. So look again, I say again, look at the protection offered to employees. And often these intimidatory tactics happen on both sides, both the employer side and the employee side. Don't know your rights very carefully, you would think, oh, well, they're offering us 12%, we should be lucky we're getting a raise. You know what? You're saying, well, that, if we don't accept it, then we have to then leave. That is like that case, all right? However, we mustn't lose sight of the fact that an employer can quite legitimately say, well, if I'm going to give you the 20% you want, and you not accept the 12% that I offering, then you must realize that we will be out of business in 3 months. Okay. Now that is not doesn't perhaps fall within this category here. So you can't say that that was a reason for dismissal, because the employer can quite legitimately say that if you can show it. So, well, if we're going to increase everyone's salary to 20%, then in 3 months' time, we will have to restructure. You won't be able to offer employment to everybody, and you could well lose your jobs. All right. So remember, you can dismiss somebody during a strike and a lockout for misconduct and operational requirements. And this is quite possible if the employer can show that it's through operational requirements that we cannot hold you longer and we have to dismiss you. And then provided he follows the procedure, it can end up like that. So that's just another ground. And in here, section D, this is all section 187 of the LRA, which deals with automatically unfair dismissals. Another ground is section D, that the employee took action or indicated, listen very careful to this, that the employee took action or intended an intention to take action against the employer by exercising any right conferred by this act or participating in any proceedings in terms of this act. Now, this is both protection for collective labor law as well as individual labor law. Okay, and can border on the line of unfair labor practices. You know, where sometimes people they do things which are just short of dismissal. Who was in yesterday's class? I think it was Gillian and Jane. We spoke about unfair labor practices. Remember, anything it can be for regarding suspension, unfair suspension of the employee, or any conduct falling short of dismissal. Okay. Now, many times employers will like to do this. They like to intimidate workers. It's a common thing. Okay, so if you say, I'm going to take you to the CCMA for an unfair labor practice matter, or I'm going to do this, they see you as a danger, and employees themselves are scared and frightened of taking the matter further. But here the act is saying, if you want to exercise a right, this is a very important right, guys. Just think about it. Are all of you working people? Okay, 3 yeses. So you'll know. Is it not common that you feel sort of unsure? Many people feel unsure in the workplace. Perhaps yourself. Take this further, I can kiss my promotion goodbye, or take this point on, then I may not get my increase. If this happens, I'm going to get prejudiced. If this happens, they're going to fire me. So if you get dismissed because you did nothing else other than to exercise a right that's given to you in terms of the LRA, this is a broad cover. Okay, you have taken action, or you notify people, that you're going to take action. You notify the employer, you make it clear that your intention to exercise your right uh, in terms of this act, any part of this act, then you can, that's proven. You're going to have to now prove that. Then it comes out from the employer side when they must show that it was fair. Then it will be considered an automatically unfair dismissal. And why did I say, do you want to make to fall under an automatically unfair dismissal? What is the reason if you refer a matter to the CCMA or to the bargaining council, why would you want to have your dismissal under that heading of automatically unfair? You want it because of the bigger compensation that you can get. You can get double the amount of compensation than you would under a normal unfair dismissal matter. Yeah. Now here's a big one, and I think you all ladies over here. So section 187 subsection E says that it is an automatically unfair dismissal if the reason is that the employee's intended pregnancy, okay, that intended pregnancy, or any reason related to a pregnancy was the reason for the dismissal. So just look at these words. Yeah, the fact that the lady is pregnant or intends to become pregnant, any reason related to your pregnancy, like the employer may find it a bit of a difficulty to have you there and is finding a way to get rid of you, or you went on maternity leave and turns around after your 4 months and says, well, sorry, man, we had to fall in that position. We can't rehire you now. So if you're going to be pregnant, then don't come back. Things like that. If this is related, and look how broadly it's phrased, pregnancy or intended pregnancy. You may not even be pregnant yet, but you mentioning it will give you that protection. So it will be considered automatically unfair dismissal. So like I repeat again, you could be reinstated, 1, and 2, you get double the normal compensation amount. So I should rather qualify that and say up to, not definitely 24 months double, but up to the maximum allowed. Um, 187F, that the employer unfairly discriminated against an employee directly or indirectly on any arbitrary ground, including but not limited to race, gender, sex, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, political opinion, culture, language, marital status, or family responsibility. So these are this is a bit of a different thing, and I tried to make that clear yesterday between unlawful discrimination matters and unfair labor practices. This is your unlawful discrimination matter. Okay, where along with this can be read together with the Employment Equity Act also, which also prohibits discrimination. Okay? So this is expressly excluded, and when you are taking a matter, on unlawful discrimination matter, then you are also entitled to up to 24 months. So it can be on a listed ground or an unlisted ground. Okay. There's just 2 more things before we can close. It's also an automatically unfair dismissal. And the reason given is that a transfer a reason related to a transfer contemplated in section 197 or 197A. Now that has to deal with when a business is sold. Okay, what becomes of the employees when the business is sold? Okay, when a business is sold, there's a going concern. The employers, when it is sold, the employers have an expectation now to be taken over by the new person who takes the new entity that takes over the business. And when that happens, the new employer cannot simply say, what happens to the employees must be clearly agreed upon, with the new purchases of the business when the business is sold. So that a provision must be made for the employees. If the new employer takes over and he dismisses the previous employees, this will be a major problem. Be an unfair dismissal, automatically unfair dismissal. Okay. So look at section 197 and 197A as well. Okay, so it's no excuse for a new owner of a business to say, oh, well, that was between you and the previous owner. I've now taken over, and it is unfortunate that you've lost your job in the process. Not in terms of section 197. Okay. And then lastly, when you make a contravention, the reason for the dismissal is if you've made a protected disclosure. And remember last night we spoke about in individual labor law protected disclosures, which is, remember, you have to prove two things: protected disclosure and occupational detriment. Right? If you make a protected disclosure is where you can show that the employer is violating a law, or committing a crime or doing something against an established law. Then the fact that if that would be the disclosure, and that if you were to do so, you would suffer prejudice in the form of a loss in benefits, dismissal, disciplinary action, demotion, or any of those kinds of things. That would be the occupational detriment, and that would be an unfair labor practice also at the same time. So if you make a protected disclosure, so we had that example yesterday of the person reporting his employer for not filing but unemployment insurance fund, or not paying over unemployment insurance fund deductions, the Department of Labor. So if you were to be dismissed for that ground, it would be an automatically unfair. Jane and Jillian can recall that discussion from yesterday. Okay, we are nearly time up here now, guys. So here we go. An automatically unfair dismissal covers all those cases. And, it is important to know, a lot of it is covered, related to strike actions. Just to recap those three reasons that you must know for participating in a strike, or participating in an activity, or even indicating an intention to do it, refusing to do work if you're not involved in the strike pairs, but you refuse to do work that person who is involved in the strike is supposed to do, and you refuse to do his work, and you get dismissed for that, that's automatically unfair. And also when the employer is forcing you to accept a term before or during the process of collective bargaining, if it's a matter of mutual interests, an employer is threatening that if employees don't accept it, they will get dismissed. So, and if they are dismissed because of refusing to accept such a thing, it will also constitute an automatic unfair dismissal. And then lastly, the fourth one, that any right that you exercise or intention to exercise any right under the LRA, and you face dismissal because of it, simply by exercising a right. Okay, guys, that is our time, I see. Are there any questions? Julian, Jane, Celeste, any questions? Okay. Just don't forget, guys, that you can, should you require individual sessions, one-on-one sessions, is a form. I think Adele has sent out that form a few times already. If there's a particular aspect that you want me to deal with on one-on-one consultation, it can also be arranged. I see people should make use of it. Don't be shy to use it. You should use it. It's a service. It's um, available for you as a student. So you need assistance, or students that do need assistance, your fellow students, tell them about that as well. All right. So I shall see you guys on Monday or Tuesday. I know Jillian and Jane will be there, and Celeste, I don't think she's in 2601. I'll definitely see you guys next week then. All right. Thank you.
Okay, thank you.
Thanks, Jillian.